Just because someone wants something does not mean that they should have it if there are no grounds for having it. The desire of the National Park Service must be grounded in evidence and scientific data that is brought before this commission to satisfy the 8 criteria of Chapter 174C. We believe that thus far, and this proceeding has been going on for a year and 2 months, I believe, no evidence has been submitted to this commission to demonstrate that any of the 8 criteria have been satisfied. Even the quorum staff, in its staff report, seems to indicate that that is so with regard to the threatened or alleged threatened resource that we are here to protect. I will tell you that as I reviewed this case, it was puzzling to me as to why none of the 8 criteria seem to be met, both from the evidence and the scientific data thus far. And then it dawned on me that 174, the Water Code, was adopted to protect the resource, water. In fact, Chapter 174C, Section 174C 41, which is entitled Designation of a Water Management Area, says, when it can be reasonably determined after conducting scientific investigation and research that the water resources in the area may be threatened by existing or proposed withdrawals or diversions of water, the Commission shall designate the area for the purpose of establishing administrative control. It is the protection of the water resources which is behind the water management area designation process. When I struggled to figure out why the 8 criteria were not met in this case, it dawned on me that the National Park Service's petition is not about protecting the resource. It's about protecting the park, the impacts to a park. The Water Code was not established to address impacts. The water regulations which govern the Water Department and the state water controls were enacted to protect the water impacts. Water designation is to protect the resource. The National Park Service is not here asking you to protect the resource. They're asking you to protect the park. It's a big difference. I don't believe the petition, therefore, is appropriate to be before this commission. If we go beyond that, and let's assume that it is appropriate, which I don't think it is, the mayor struck upon what I think is the penultimate issue before us, before you. And that is whether you feel comfortable that the Department of Water Supply and the County of Hawaii is able to manage these water resources and to fulfill its public trust duties under the state constitution. If you feel that they are not, then it is your perfect right to protect the resource, to impose the overlay regulation through the water management designation process. In fact, the legislature gave you all the sole power to do that. In other words, you don't need a third party to bring a petition before you to designate. It can be done by the initiation of the chairperson of your commission to do so at any time. At any time. Therefore, we believe that unless you believe that there is mismanagement by the Water Department or the County of Hawaii agencies, or there is an incapability of those departments or the Water Department to manage the resources of the Keauhou aquifer system, you should not designate this area. There is no basis to do that. I will submit to you that in reviewing the record over the last year and 2 months, there doesn't seem to be any evidence of mismanagement or incapability to manage this resource properly and to fulfill the public trust duties under the state constitution. So you have two issues before you. There is no criteria being met as to the threatened resource. The Park Service is not asking you to protect the resource. And secondly, there is no evidence to show that the county is mismanaging or irresponsible or incapable of managing this particular resource. We believe that this petition should not be before you and therefore should be dismissed. Let me address something else here. The County of Hawaii is willing and has been willing to meet with the National Park Service to discuss how we can resolve this issue of impact to their park. In fact, in November 28th of this year, the Water Board sent a letter to the National Park Service stating that the Water Board remains willing to discuss matters relating to the water needs of the county residents, but we have not heard any type of proposal from the NPS on ways to work together regarding this issue. Repeated requests for further discussions on that issue have gone unanswered by the NPS. Should the NPS be sincere in its commitment to finding a common ground on this issue, the Department of Water Supply of the County of Hawaii and the Water Board remain committed. We have made offers to sit down with them to work these out. I submit to this commission, and I disagree with the National Park Service in regard to any type of mediation. The National Park Service said they didn't want you to hover over us while any negotiations were going on. They didn't want this decision to be hinged upon the outcome of any discussions. We have just the opposite position. We think you play an important role in mediating this event and this situation, which is of critical importance. We would like this commission to withhold the decision of this petition pending negotiations between us and the National Park Service to reach an agreement on what measures we can take from the county side to allay their concerns regarding the impacts to this park. We make that offer to you and to the National Park Service. In good faith, we believe that with you involved in that process, the parties will cooperate and come to the table to seriously negotiate a settlement of this issue without having to make a very difficult decision that affects and is, in my opinion, divisive of this community. Thank you very much.